In 1996, the International Court of Justice responded to a request by the United Nations General Assembly and the World Health Organization to provide an advisory opinion on the legality of the threat or the use of nuclear weapons.
The initial request for an advisory opinion regarding the legality of the threat or use of nuclear weapons was presented by the World Health Organization on September 3, 1993. However, due to the sensitive nature of disarmament at the time, the international system was adjusting to a post-Cold War international order. Furthermore, questions surrounding the ICJ's legal authority on the matter, the court was forced to deliberate regarding their own capacity to hear the case.
It was determined that the advisory opinion had to go through the UN General Assembly and not the WHO unto itself, who lacked the jurisdiction to make such a request of the ICJ. The court rejected further arguments that it should refrain from rendering an advisory opinion, as it may have negatively affected disarmament negotiations, and that the court would be exceeding its authority by acting as a lawmaker. In a 13-1 vote, the court stated that it simply states the existing law, even if it must sometimes specify the scope and application of said law. Moving on to the matter at hand, the court deliberated the UN General Assembly's request to advise as to whether states are permitted to use nuclear weapons under international law.
The court found that there is neither customary nor conventional international law a comprehensive and universal prohibition on the threat of use of nuclear weapons as such. However, the court unanimously found that the threat or use of nuclear weapons that is contrary to Article 2, Paragraph 4 of the Charter, and that fails to meet all the requirements of Article 51 is actually unlawful. Article 2, Paragraph 4 states that members shall refrain from the threat or use of force against any other state that is inconsistent with the purposes of the United Nations, while Article 51 lays out the state's rights to self-defense. Certain states propose the argument that the use of nuclear weapons was a violation of international law by reference of existing norms relating to the safeguarding and protection of the environment, given the devastating impact of nuclear detonations. This was also rejected by the court, which stated that the environment treaties are not intended to deprive states of rights to self-defense under international law. However, they advised that states must take environmental considerations into account when assessing the necessary and proportional pursuit of military objectives.
In summary, the 1996 ICJ advisory found that the threat of or use of nuclear weapons is not illegal under international law, despite a large part of the international community moving towards complete nuclear disarmament. Provided guidelines set out in Article 2, Paragraph 4, and Article 51 of the United Nations Charter were followed. The court also stressed that a state is obligated to take environmental impact into account when determining a proportional cause of military action.